why is intellectual property important to the states at all? And I think in answering that question, it's important not to just look at those who hold the intellectual property themselves, the property owners, but it's also important to look at the downstream industries that have to use this intellectual property in their daily activities. And so when you have companies stealing intellectual property, not paying for it in order to get a competitive advantage over their, over their competition here in the United States, it's that effect on downstream industries that concerns us in the States. So what am I talking about here when I talk about examples of intellectual property that can have an effect on downstream industries? Well, if you turn to the slide that has a map of the United States with these pretty pictures, it's more than just the pictures that you see here. So you might see the picture of the prairie dog and the windswept prairies. Well, if you think about wind turbines, for example, or solar, these are industries in which intellectual property, both on the hardware side and on the software side, is important or is becoming important. If you think about fracking, that has made states like North Dakota and Ohio and Pennsylvania incredibly rich, fracking also depends upon intellectual property as well, and people's willingness to pay for the use of intellectual property to make it a competitive exercise. Then there's Wall Street, which depends on financial software. There's Oregon with its wood products, and of course the state of Washington, which General McKenna will be talking about. So in other words, the use of intellectual property in downstream industries concerns us in states because we want a fair competitive process where everyone is paying the license fees that are required to use intellectual property. So now to understand how the states can address downstream industry problems involving the theft of intellectual property, it's important to look at state unfair competition laws. Now, as former Chairman Kovacic pointed out, federal unfair competition laws are headquartered in Section 5 of the FTC Act. However, the states have their own baby FTC Acts, and for California, that is in Section 17200 of the California Business and Professions Act. So what are the powers of the California Attorney General under that act? Well, we can seek civil penalties, we can seek restitution, and we can seek forward-looking orders from the court that is designed to address harms to the competitive process and remedy those harms. And we can do all of this without having to show standing, which is very important. Now, what are the various uses of federal and state unfair competition law? Now, I know our audience are experienced practitioners, and you've already heard from former Chairman Kovacic, so I won't bore you with the details. But essentially, you can use federal and state unfair competition laws to remedy violations of antitrust laws, to go after violations that, if completed, would be violations of antitrust laws. But there's also another use of federal and state unfair competition laws, which is broader than federal and state antitrust laws. This is what is often called a pure Section 5 case or a pure 17200 case. And essentially, we can go after unfair business practices, even if those practices are not per se a violation of antitrust law, if those practices significantly threaten or harm competition, and if there is no legitimate business justification or existing law that excuses that conduct or gives it a safe harbor. So when we talk about a practice that significantly threatens or harms competition, it's important to note that we don't have to actually show market power or a market-wide effect, such as you normally have to show to make out an antitrust violation when it's not per se. It's also important to note that the standard I discussed here comes from the California Supreme Court case of Celtec, which was a competitor versus competitor lawsuit. We in California believe that when it is not a competitor versus competitor lawsuit, that the standard's even broader than an analog to Section 5. However, for purposes of this discussion today, we'll assume that what prevails here is the Celtec standard, which is an analog to Section 5 of the FTC Act. Now, I should say that the use of state unfair competition laws to remedy violations that are not antitrust violations has not gone unnoticed. There are folks who do argue that you need to show a specific injury to consumers, such as having to pay higher prices, in order to make out a violation of state unfair competition law. However, there are others who have noted that there is no such requirement, at least as a matter of state unfair competition law. And as you've heard former Chairman Kovacic point out, perhaps not as a matter of Section 5 either. And that indeed, if you have an unfair business practice that hurts market efficiency, such as the use of theft to gain a competitive advantage, that can be enough. Now, I'm going to quote the late Judge Bork here, or rather paraphrase him. But the late Judge Bork was always keen on pointing out that when you have a practice that hurts efficiency, that ends up hurting consumer welfare. And it's that kind of practice that you should go after. Now, we all remember the Microsoft case. And we could go over whether the Microsoft case did represent a violation of Section 2, the antitrust laws, or not, although California's view is on record. However, it's important to note that what the courts found was that even though the practices that Microsoft engaged in were perhaps speculative in terms of their impact on consumers, after all, how do you value, from a consumer perspective, the value of having a Netscape browser versus an Internet Explorer browser? Nonetheless, the view that was articulated by the courts, which was the late Judge Bork's view, was that this hurts efficiency and thereby hurts consumer welfare, and so that even under the antitrust laws, you could go after these practices by Microsoft. So from the viewpoint of California, we see the unfair competition laws as the use of an old 20th century law, because the unfair competition laws in California go back to the 1930s, to address these 21st century problems. And we see it being more flexible than the use of antitrust law, where a number of questions have to be answered to be able to figure out whether antitrust law can be applied to this set of circumstances or not. And if you want to know what kinds of questions you would want to ask, you can take a look at the relevant slide. So what are examples of where unfair competition law can be used to address intellectual property right abuses? Well, I'm about to talk about our piracy case. But just to give you another example, so that you all don't think that our case is an orphan or unique or we somehow made it up, take a look at the patent holdup cases and take a look at what the FTC has filed with the ITC and others. And you'll see that this is exactly the same kind of problem. And the FTC has come up with the same kind of remedy. So with patent holdup, we all know what it is, and it is defined in my slide. But that's an example of where the FTC has used unfair competition law to address a problem that can't be remedied under the antitrust laws, yet poses a threat to competition itself. We in California believe that the pirating of software to gain a competitive advantage is a similar example. So let me turn to that. Now you can see the graphics involving the two apparel companies that we sued, Ningba Beyond and Pratibha Syntex. One of the two companies is in China, and the other company is in India. Now, the details of our lawsuit can be found on our website, and I provided the address for that. But let me give you at least a taste of what the basis for our assertions in that lawsuit are. So, first of all, we've pointed out that what we have here is the pirating of software. This is back office software, design software, and security software, whereby these companies, Ningba Beyond and Pratibha, failed to pay license fees to be able to use this software under copyright. And as former Chairman Kovacic has pointed out, the fact that it is uncontroverted in India and China, as well as here, that you cannot use copyrighted software without paying license fees. That goes all the way back to the Berne Convention, and it is in the laws of these countries. So therefore, the pirating of this software is theft. We believe that the pirating of this software, the theft, has both short-term effects and long-term effects. And both of those are important. So short-term effects. In an industry involving low margins, not paying license fees gives apparel companies more money to hire additional employees and pay for research and development. And that money compounds on itself year after year in a low-margin industry. Long-term effects, in an industry where you can't get intellectual property protection, that industry is going to relocate elsewhere. We've all seen what we like to call now inshoring, where industries, manufacturing is coming back to American shores. And the apparel industry in Los Angeles is a great example of that, as I'm going to discuss. However, if you can't protect IP here, then that inshoring is just going to become offshoring all over again. Now, if you take a look at the next slide, you'll see some more cool graphics, at least I hope they're cool, involving the strength of the nexus to the industry. So you see here Adobe and Semitex. We could have added Microsoft and a couple of other firms as well, such as Corel. And Adobe does design software, Semitex does security software, and Microsoft is important for back office. And in a low-margin industry, you need this software to be able to effectively compete. So you see over on the right, you have American Apparel, 3 Dots, Splendid, and Gap. Well, some of these companies are American apparel companies that compete vigorously, that manufacture apparel here in the United States. So if you're Gap and you're a retailer, okay, and you depend on making sure you get the best competitive price, who are you going to go with? Are you going to go with the American companies that are paying license fees? Or are you going to go with overseas companies that can save you even a little bit of money because they're not paying for that copyrighted software and they've now got a competitive advantage? And if you turn to the next slide, it's important to emphasize the nexus here with California. And this gets to the point that I just made a little bit earlier. Los Angeles has a vibrant apparel industry. If you Google Los Angeles and apparel, you'll see what I mean. There are apparel companies in Los Angeles that compete vigorously. There is the Fashion Institute, where research into new methods of apparel is done. There is Cal State Northridge, where yet more research is being done. And you can see the high-tech future in apparel unfolding in Los Angeles. So for us here, we think that there is a very strong nexus between what these two apparel companies are doing abroad, Ningba Beyond in China and Pratibha in India, and Los Angeles, California. But they're not just the short-term effects, they're also the long-term effects. So as I said, where we see high technology now sweeping through apparel and transforming that industry, it's important to note that these unfair business practices also hinder innovation in the state of California. Because why bother to innovate if people are just going to steal what you've come up with and you can't protect it? So people often ask me, well, Emilio, this is all well and good, but we don't think of apparel as being high-tech. Can you give us any examples? And I have lots, but this latest one I thought was really cool, being a Star Trek fan, so I went ahead and used it. And that's the 3D printer printing a shoe. So if you turn to that slide, you'll see a woman's shoe. I'm sorry, the image is a little bit compressed, but you can see the you can see the shoe sitting there in the 3D printer. And that's just an example, one example of many, about how apparel is being transformed by innovation here in the United States and specifically in the state of California. Now, there are a couple of other points I would like my audience to think about, because I often get asked. First of all, it's important to note that existing international treaties and laws overseas do not address these downstream effects. This is what we could call sort of a black hole in international trade and international intellectual property law. And we're filling that hole. The other point is that this lawsuit that we've brought does not violate any international treaties. We're just as willing to go after domestic companies that try to get an unfair competitive advantage in this manner as we are willing to go after foreign companies. So I'd like to finally address briefly what we're seeking by way of remedies. Civil penalties, we can get $2,500 per violation, and what a violation is very flexible under the law. On the injunctive side, we're seeking a ban on piracy. We are going to seek a bar on products entering into or transitioning through California. So, as you all know in the audience, a lot of imports into the United States come through the Port of Los Angeles and the Port of Oakland. We will be seeking an order barring Ningbus products and Prodibas products from coming into our state, even through consignees and agents. And that is something we are very confident we can get through our unfair competition law.